have looked at this and made recommendations saying, perhaps in terms of the criminal prosecution or proceedings, this is what we require to ensure that the judiciary really lives up to this billing as the last hope of the common man. Have we done this? And then perhaps on that basis, we can then say they didn't do it? Because some think we haven't really done that.
Well, let me start from this issue of the section that says all election dispute must be completed within 180 days. Well, I don't think it's a constitutional matter. And that has been inserted into the Constitution politically. Because even in our normal court system, I'm not saying election dispute should drag on till eternity. That's not my position. But there is no way practicable that you can probably conduct election and dispute arising therefrom should be concluded from the election tribunals up to Court of Appeal and Supreme Court within 180 days. It is not practicable.
Really?
And the essence is for the riggers to take benefit of the aftermath of their rigging.
Why is it not practicable?
It's not practicable. As lawyers, you have to file process. There are times when man-made difficulties may not allow you to even file your petition within 180 days.
Is this not giving...
When there will be collusion from probably electoral officers.
If they have specialized courts for elections, would that make it easier?
My brother, as long as that is manned by Nigerians, it might not be practicable.
That you cannot file petition within 180 days?
It might not be possible. I am talking of Nigerian factors. May come in. Wherein probably the loser intends to get some documents. We have seen instances where you apply to court to ask that the court mandates INEC to allow you, search for some documents. That may not be available to you. Maybe within 30 days, 60 days. And you have certain numbers of days to file your petition. Before you do that, the date has lapsed. We have seen elections be on this section, not the fight. Oh, you have not been able to finish or something. And my Lord will say, oh, their hands are tied. It's a constitutional matter. Go back to the National Assembly and allow, move for the removal of such session.
But are we not seeing some improvements, adjustments being made with respect to possibly or indirectly with respect to this one? Because remember the CJN lately, she keeps telling judges time and again, if you cannot deliver at least 3 or 4 judgments in a year, you've got no business, or they will look into your matter. So with those warnings coming in, wouldn't judges sit up and administer some of these cases quicker than they have been doing?
We have to also be very careful in doing that. We have to be very, very careful. Because though judgment is enjoined to be delivered on time, we expect that justice delayed is justice denied. It's an axiom. But we also have to be very careful. There are instances where you rush in file processes and all those things that at the end of the day, due to technical or probably some lacuna here and there, the person that ordinarily is supposed to win might end up losing. So in as much as I appreciate the position of CJN, we also have to be very careful. We are practicing lawyers. We know what we face in court. We have to be very careful so that at the end of the day, you not just rush. And justice is not met at the end of the day.
All right, we'll take a break. But when we return, perhaps you take it from there. What is it that they go through in courts that may be described as you rushing and not even delivering judgment on time? So you give us your practical experience as a practitioner. That's when we return. Welcome back. Commander Samson is still here with us. He's a legal practitioner and former publicity secretary of the Nigerian Bar Association Ikeja chapter. Give us specifics now. I mean, if they say 180 days and the CJN says dispense of justice quickly, what is it that is wrong with that? I mean, what should we be wary of while trying to dispense justice quickly?
Yes, we should be wary of a lot of things. And in practical experience that what we've had in court, lawyers are also culpable, our colleagues, in the quest of making money quickly. I'm not going to disparage my colleagues here, but we must say the truth. Lawyers are also involved in this shady deals. If, as enjoined by the CJN, that judgment will be delivered, certain numbers of judgment be delivered within so date, some unscrupulous practitioners will take the advantage of this to file processes surreptitiously, even without serving the other party. We have seen it. All you need to see is barely sheriffs of the court at your doorstep, levying execution. You have to go back to court to undo what has been done. I experienced one recently, this year, not less than 2 months. A judgment that we have executed in 2007, warrant of possession, which we call Form O, had been taken. Some disgruntled members of the same family went back to the same court in connivance with some officers of the court. Removed some files, brought the file, repackaged the file back to the judge.
Wow.
A warrant was signed. Execution was levied again.
Isn't that an offense?
That is under investigation. As I'm talking to you, it's under investigation. The judge was dumbfounded. She was misled.
Wow.
Is there no way to have verified? I mean, she had a copy of she had her own copy.
I am telling you, I'm not going to deduct the judge because in the open court, I was back in the open court. She said I was misled. And that was, I believed her. From what we later found out, and the investigation is still ongoing.
So you're saying if you had a longer time,
I'm not saying we should have a longer time, but I'm saying we should be very, very careful and scrutinize all processes that are filed in court. And when a lawyer appears in court, the judge should also have to be sure of what the lawyer is saying.
What about streamlining? How can these court processes be streamlined so that they don't appear so cumbersome?
We have the processes in court. The 2004 rules, the 2012, the new 2012 rules, we have procedures. When papers are filed, the claimant files his processes. The defendant has some numbers of days to respond to that process is filed. 42 days in Lagos, 60 days in Ogun State. After the filing, there are steps to be taken. The defendant, if he does not respond, there are steps to be taken by the claimant.
Okay, so what I'm saying is, where the election cases, they say 180 days. Now, if you have 42 days...
No, I'm talking of normative. I'm not talking of electoral matters.
In electoral matters, what's the duration? After someone files his papers, what's the duration of response?
There are times 14, 7 days. It all depends on the arrangement. The rules are next to the Electoral Act. I cannot pinpoint the number of days now so that I won't misinform the public. I cannot tell you directly now the number of days that you have to respond, file your petition when the people.
But you say it's between 7 and 14 days.
Exactly.
And you're saying that 180 days is too short.
I'm not saying it's too shocking, but we have to be very careful because a lot of cases have been lost on this issue. And lawyers. That's why I'm saying practitioners. We are most of us are culpable. We know that in order to hide under this section of 180 days, any little issues, you find an appeal. Before you compile your records, even interlocutory applications, you find your appeal, you move from court of appeal to Supreme Court. By the time you come back, that 180 days might have lapsed.
But same with it. Okay, go ahead.
I was wondering, this is not strange to us. It's not the first time, because previously they say time and again, in the previous republic, you had cases concluded before the swearing in of elected officials, and that's what they're trying to return to have some sanity, and not that the cases drag on forever.
Was there justice then? What was the outcome of what happened in 1979?
You don't think there was?
There was no justice. Chief Obafemi went to tribunal. That was concluded, so to say, quote unquote, before the swearing of the President Shehu Shagari. What was the outcome? Was there justice? What happened in Ondo State? What happened in Ibadan State? There was no justice. And I'm saying it with every